interrupting the court.
You're asking me a question. You're asking me a question. Let me ask. You guys would not let me say anything in this courtroom. Okay, well, I'm talking right now. I am talking right now, Your Honor. I'm talking.
No, you're not talking. I just muted you. And appearance, counsel?
Good morning. Good morning. I'm Cheryl Luckoff on behalf of the plaintiff.
All right, thank you.
This woman walked into Judge DeSanto's courtroom like she was auditioning for a reality show. Loud, dramatic, and completely allergic to accountability. Within seconds, it goes from routine to ridiculous as she interrupts, grandstands, and basically turns the hearing into her own personal pity parade. She's not confused about the charges. She's just hoping if she talks long enough, the court will forget why she's there. What most people don't know is judges can deny leniency just based on disruptive behavior, and she's practically speedrunning that disqualification. Do you think she's truly losing it, or just stalling because she knows what's coming? Let's dive in and watch.
And Ms. Stevenson, your name for the record, please.
Markia Stevenson.
Okay, thank you. And so, Ms. Luckoff, this is the date scheduled. Okay, so there was a bankruptcy stay that was entered November of 2022. And then there was an order reopening the case after bankruptcy. And so this is the hearing for that. And so, counsel, you had an opportunity to speak to Ms. Stevenson in the breakout room, correct?
Yes, Your Honor. And I'd like to create a record right now. So the defendant had her initial hearing on November 4th, and she filed a bankruptcy right before that hearing. She did appear, she was given her rights. Her bankruptcy, she had filed a Chapter 13. It was dismissed for failure to comply. She paid zero into her plan. She had not paid herself. She had not paid the landlord rent since September of 2021. Since that time, she had Sarah payments. She has a balance right now of $12,106, Your Honor. She informed me in the breakout room she's filed another bankruptcy. I don't have any notice of this bankruptcy. There's no bankruptcy attorney here, but that is what she is asserting. We are going to be objecting to any discharge because if she filed it right before this hearing again. And there clearly seems to be some abuse here, but she can provide the case number for the court. And, if a stay needs to be in place, then a stay needs to be in place. But I have no knowledge personally of any bankruptcy, and my client has not received a notice of bankruptcy proceedings.
Okay, Ms. Stevenson, please raise your right hand.
Yes, Your Honor.
Do you solemnly swear from the testimony about
I've been filed bankruptcy.
Ms. Stevenson, please raise your right hand. Is your right hand raised? I can't see.
Yes, ma'am.
Okay, do you solemnly swear from the testimony you're about to give this matter to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, thank you. Okay, and so, Ms. Stevenson, I'm not sure about your connection. It seems to be a little bit spotty, but, okay, so initially you filed.
She's got the posture of someone who's about to file a complaint before the hearing even starts. That kind of preloaded attitude doesn't just irritate the court, it signals to the judge that cooperation isn't in the forecast. And believe it or not, judges can legally factor in courtroom behavior when deciding everything from sentencing to future credibility.
Bankruptcy in November of 2023, correct?
Yes.
And then that was Chapter 13, is that correct?
Yes.
And you were ordered to make payments within that bankruptcy case, correct?
Incorrect.
That's incorrect?
Yes, ma'am.
Okay. So Chapter 13, were you required to make any payments at all?
I fired my lawyer for the Chapter 13. I reached out to Royal Woods because the payment plan that he came up with, I did not agree with. So I fired him. I contacted Royal Woods and I told them about my new attorney. And I just gave Miss Lockoff the case number.
I don't have the case number. Her connection was spotty. She said 23. That's all I have, Your Honor.
Okay,
I can give you the
Ms.
case number, Your Honor.
what is the case number?
Okay, 1 second, please. My case number is 23-44007.
When was that case filed?
It actually, I contacted them in January, and my lawyer told me to contact him when I received the court papers for eviction or a hearing. So I contacted him, and he filed the case last week. And I did contact Royal Woods as well.
Who did you speak to?
I spoke to Andrew at Royal Woods, and I informed him, and also a lady named Cheryl at the office, at the the corporate office. She emailed me and actually called me. I told her, I said, I have another case, and I don't know why we're going to court. I still need the 30 days, to vacate the premises. She said, okay, we're still going to take you to court. I said, okay, fine. I said, you guys are wasting your time because I'm on another automatic stay.
She's a professional. Your Honor,
So are you?
respectfully, just
I'm just a moment, Ms. Luckoff.
Yeah.
So are you planning on relocating then, Ms. Stevenson?
Ma'am,
Yes. Are you planning on relocating then?
could you repeat that, Your Honor?
Are you planning on relocating?
At my leisure.
At
at
your
my-
leisure.
at my
That's not how
time.
that works, man. On your own time. That isn't how this
Yes,
works.
ma'am. See, a bankruptcy.
I'm sorry, your connection is not very good. What did you say after bankruptcy?
I don't even supposed to be here, Your Honor, and I don't even supposed to be here.
Why not?
This is not bankruptcy court. This is not bankruptcy court. I don't even have to explain myself.
Ma'am?
I have rights. I have rights.
Well,
I'm supposed to be here, Your Honor. You are not a bankruptcy judge. You are not a bankruptcy judge.
You are absolutely correct. I am a district court judge and I have jurisdiction over this matter because we do not have anything in our files or anything that was filed by you or any attorney representing you that would support your claim that you have filed another bankruptcy case.
I gave you guys the case number on record, so you guys can try me if you want to.
Ma'am, where is the documentation regarding your case? You should have some paperwork from, please stop interrupting me.
I will email it to Ms. Lockoff right now.
Please stop interrupting me. You can email it to the court at 27dc@yn.mi.gov.
1 second. Do you want me to do it now? Because I will do it now.
Yes, ma'am. We're going to take a brief recess. We're going to go off the record so you can submit that. Thank you. Okay.
What do you want me
so
to do?
I just wanted to be able to see you. That's all. I can see you now. So I did receive your.
She's acting like the courtroom owes her a refund for bad vibes and overdue bills. There's a difference between being stressed and being combative, and she skipped the line straight to hostile. Judges don't deal in sympathy when you show up swinging. They deal in orders, and courtroom conduct can absolutely tip the scales. This isn't eviction revenge, it's legal reality, and she's treating it like an open mic night.
Email regarding the communications from Fairmax Law. So I'm going to forward that to, reporting that to Ms. Luckoff. And then Ms. Luckoff is accessing your previous case so that she can send a copy of the register of actions to the court so I can review that. So, because this appears as though there is a skeletal bankruptcy petition and you still have 14 days before your case is actually filed or dismissed. So it doesn't appear as though there's a bankruptcy case at this point that would require this court to issue a stay, to comply with a stay, nor has there been a stay presented to this court.
I don't know what y'all talking about, but I don't mean to
I'm sorry, you're
interrupt you,
breaking up. I can't. You're breaking
Your
up,
Honor,
Ms. Stevenson.
but my case.
Ms. Stevenson,
My
I
case
didn't hear, Ms. Stevenson, I'm not catching a lot of what you're saying because it's a bad connection. So I'm not catching everything you're saying. So can you please move locations? Okay, Ms. Stevenson? Can you please unmute?
I'm sorry about that. I'm here.
Okay,
Yeah.
hopefully you have better connection right now. Okay, so the court will note the, so I was just going through the procedural history, and based upon your 22 bankruptcy case, your case was dismissed March 6th of 2023. But the final decree and the closing of the case wasn't until April 25th of 2023. And it indicates that the order, the United States Bankruptcy Court, Eastern District of Michigan, Southern Division, Detroit, signed by Judge Maria Axel, the United States bankruptcy judge, indicates that the matter was scheduled for hearing on March 6th of 2023. And an oral motion to dismiss by the Chapter 13 trustee was not opposed, and was not opposed by the debtors who were present or counsel represented them. It was dismissed for poor pay history, which was 0%. And therefore the case was dismissed and automatic stays issued were terminated. We'll also note that the documentation that was submitted by Ms. Stevenson to the court indicated that there was a skeletal bankruptcy petition that was filed. And Ms. Stevenson, what date was that skeletal bankruptcy petition filed? You're muted, just so you know you're muted. Please unmute. I'm sorry, what?
What are you talking about?
Well, your attorney on your 23 bankruptcy case filed a skeletal bankruptcy petition. What date was that filed?
It was filed completely. I don't know what that word means that you're saying to me. What is skeletal?
I'm reading from the document that you sent to the court.
Filed a skeletal bankruptcy like it was a magic shield, then showed up with no details and even way less awareness. It's literally designed to be step 1, temporary coverage, not a courtroom mic drop. The judge isn't grilling her, she's asking the most basic timeline question, and somehow that's become an unsolvable mystery. This isn't injustice, it's just what happens when you treat legal filings like a casual Google form. Your attorney stated that they completed a bankruptcy analysis. Excuse me. Please stop interrupting the court, because we can't record more than one person at a time. Ms. Stevenson is no longer on here. She dropped off. The court did not remove her. I'm just making that a record right now. Ms. Stevenson, please unmute.
You guys would not let me say anything in this courtroom.
Just one moment. Just one moment. Your connection has not been good. And when you start answering a question, I'm not hearing everything you're saying. So I'm asking you to stop talking.
Okay, well, I'm talking right now. I am talking right now, Your Honor. I'm talking.
No, you're not talking. I just muted you. Now, please stop, because I see that you're still talking. You can continue to waste your breath. I muted you because your connection is poor. I cannot hear what you're saying because it's breaking up. So, have you moved to a new location? Have you moved to a location that you have better connection? Just so you know, I muted you, so you'll have to unmute.
I'm gonna type you in chat. Since you can't hear me, I'm gonna type you in chat.
I'm sorry, what is that?
I'm going to type you in chat.
No, we don't have chat enabled, ma'am. You cannot send a message to the court via chat.
Well, I'm letting you know you're not supposed to be here. My bankruptcy has been filed.
No, ma'am, that is
My
not accurate.
bankruptcy has been filed. You guys
Excuse me.
to the bankruptcy. If you do anything or try to evict me, if anything that is on my record, I don't care. It better not be on my record.
Excuse me. You need to calm down. Excuse me. You need to calm down, ma'am.
I'm supposed to be here. I have a
muted, Ms. Stevenson, because we can't catch much of what you're saying. Ms. Stevenson, stop talking. Stop talking. We cannot get what you're saying on the record because you're screaming and you don't have a good connection. So stop talking, please. Stop talking. Stop talking. Stop. I am not one of your children, ma'am, so you need to stop. You are speaking to a court. You are in court, so you need to have some respect for the court. So, as I was saying, Ms. Luckoff.
This woman is operating on legal strategy that feels less defense and more dramatic improv. It's like she skimmed one Reddit thread and decided she's ready to challenge the entire judicial system. The court isn't here for theatrics, judges can cut off arguments that waste time or confuse the record, and she's dangerously close to both. At this point, it's not about guilt or innocence, it's about whether she even knows what room she's in.
There is not another case that Ms. Stevenson filed in 2022. The court will note that, actually, Ms. Luckoff, can you pull up the names, the bankruptcy court filing to see when this bankruptcy petition was filed, please?
This
See if it was
one?
before May 3rd? Yes.
Okay.
The
Yeah.
case number is 23-44007.
Okay. Okay. This says date filed 4/30/2023. No, excuse me, 4/30, Your Honor, 4/30.
On a Sunday?
That's what it says. Let me just,
Okay.
I'm gonna open the petition here. See what we have here. If that comports. Yes, it says 4/30/2023.
Okay. All right, so what the court will note, counsel, is since there was only one case filed in 2022, well, actually, I'm sorry. When you open up the case, does it show if there is any motion that was filed along with the petition?
Let me look here. Okay, so it says petition, statement of social security number. I won't read you the whole thing, but let's see, motion. No, notice of missing documents. I do not see a motion, Your Honor.
Okay, so,
You guys mess with me if you want to.
excuse me,
I'm
stop
letting you know this
interrupting me.
now. I'm letting you
Ms.
know this
Stevenson,
now.
I'm letting you know to stop interrupting the court or you will be held in contempt of court. Stop, stop, stop. The court is going to state that the petition was filed on April 30th. So there's 14 days to file the balance of what needs to be filed, which puts it to May 14th. And so, counsel, because there was only one action filed in 2022, there is a 30-day automatic stay that was triggered. So I cannot enter a judgment stay, but what I will do is I'm only going to set this out for 2 weeks, well, less than 2 weeks, because I'm going shortly after the 14 days by which the balance of the documents need to be filed or the bankruptcy is dismissed. I'm not going out 30 days right now. So the 30th day would be on May 14th. We don't have a docket on May 19th because of the mandatory judicial conference. So, counsel, are you available on May 16th at 1:30 in the afternoon?
I will make myself available, Your Honor.
And we are doing this in person.
The only thing I need to confirm, give me 1 second, is I have an in-person. Nope, that's on the 15th. Okay.
You guys can contact my lawyer.
Excuse me, Ms. Stevenson, your lawyer has not filed an appearance here at all. So
He
your
will.
lawyer doesn't have, excuse me, then that's fine. Then your attorney will know how to proceed. You need to be here in person on May 16th at 1:30 p.m.
Why?
Because the court is going after the 14 days. We're setting this after the 14 days to make sure if the bankruptcy case is still proceeding or if it's been dismissed. So that is why the court is set
Why won't my
for May
case
16th.
be
Stop
already been
interrupting me.
filed?
Stop interrupting me. May 16th at 1:30 PM.
I will not be there.
But we'll proceed without you. You can have your attorney present, but you need to also be present. So May 16th at 1:30 PM in person at the courthouse here. Thank you. We're off the record.
Thank you, Your Honor.
Thank you.
I won't be here.
Honestly, I don't even think this was about confusion. This felt calculated, like she weaponized chaos just to stall for time. The legal system already moves slow, and when people pull stunts like this, it just clogs things up for everyone who actually needs help. What really stuck with me was seeing those little kids in her Zoom profile, because at the end of the day, they're the ones growing up watching this mess and thinking it's normal. That's the real damage here, not the courtroom theatrics, but the ripple effect it has outside of the screen. And legally, that kind of behavior can come back to bite you in family court, especially if a judge sees a pattern of instability. So what do you guys think? Is she spiraling or just gaming the system? Hit the like button if you want more unfiltered courtroom breakdowns, drop your thoughts in the comments, and thank you guys so much for watching. I'll catch you in the next one.